Number 6, Petróleos de Venezuela, the MUFG Union Bank.
Chief Judge Wilson, and may it please the court. I would like to reserve 3 minutes for rebuttal.
Yes.
The question in this case is whether the parties to debt issuance by a foreign state-owned entity under the control of an authoritarian regime may circumvent the express constitutional restrictions on that entity's authority to issue security by selecting a New York law choice of law provision. The answer is no, under both the Uniform Commercial Code and New York's common law principles. As to the UCC, Section 8110 mandates that the validity of a security is governed by the law of the issuer's jurisdiction. Here,
Counselor?
that of Venezuela.
Counselor, I'd like to start by asking you, in terms of the validity issue, what got my attention was the oral argument in front of the district court, where I think it was Mr. Bliss was representing your client at the time. And essentially, he said at page 2216 of the record that so the effect of UCC 8110 is to render irrelevant any New York law with respect to the validity and ultimately the enforceability of the 2020 notes. In your reply brief, you also say this appeal is not about whether the governing documents are enforceable, it is only about what law will decide that issue. So when you say validity, and in the argument in front of the district court, it included, Mr. Bliss included issues pertaining to, it encompasses theories such as apparent authority, ratification, estoppel, the ultra vires statute. So everything having to do with enforceability is swallowed up by the word validity, according to your argument, correct?
No, Your Honor. Actually, our conception, our interpretation of validity is quite narrow. So validity...
But is that what is in your brief, and is that what was told to the district court, is my question?
This is in our brief, and I can't speak exactly about the district court. We may have expressed it unartfully. But our position before this court and before the Second Circuit is the term validity in Section 8110, for the purposes of this case, is quite narrow. It encompasses a public issuer's compliance with express constitutional procedural requirements that are part of the issuance process and that govern that public issuer's authority and power to issue security. So in that sense, it is different from enforceability. The question of validity here goes to whether a public issuer has authority to issue security in the first place, and that encompasses such restrictions as constitutional provisions.
So how about, hypothetically, if the provision read any contract between these same parties that affects national security? Would that go to the validity of the issue? Or if you came in and you said, you know, obviously this is a very important asset, this is our national security at stake here?
Your Honor, it's different from this case, but it will depend on how the constitutional provision is written. I would say that in the hypothetical Your Honor posed, I think that would go to the question of enforceability, because that would be, it may be that...
Same requirement. You need to get approval by the public, by the assembly, if the contract affects in any way national security.
Your Honor, let me give you maybe one example. One example
But no,
would be...
but could we stay with my hypothetical? Would you say that is a constitutional provision that affects the validity of the security, under your test?
A constitutional provision that would say any contract that affects national security is invalid. That would be...
Or says any contract that affects national security requires the approval of the public assembly.
Your Honor, if it includes the requirement of an approval of the National Assembly, that would be a question of validity, because that would be an express procedural requirement.
So no matter how vague the standard, if it required National Assembly approval, it would affect the validity of the security.
Because the procedural requirement of getting legislative approval is not vague. It is very clear you have to go and actually get that approval. What will constitute a contract affecting national security is here a national public interest contract that can be determined under the relevant law, here law of Venezuela. And we actually, this would be for this.
There's no limiting principle on a national security approval, National Assembly approval, I keep getting it wrong. National Assembly approval, whatever you say needs National Assembly approval, as long as there's an argument it could affect the validity of the security or the issuer's authority, then it's a constitutional provision that falls under the UCC.
Your Honor,
process.
there is a question under Venezuelan law, but that is for the Second Circuit and the Federal District Court as to what limits how the Venezuelan law defines a national public interest contract. It's not an unlimited definition. So our expert, in fact, indicated that there's a qualitative definition. It's certain type of national contracts that do have a significant effect on the public polity.
And that seems to be an expert opinion on the law, but wouldn't that be better? I mean, I could see if that was a definition in the law, but now we have to have people come in a very vague term and assume my national security term and opine that, so we have to get underneath what we think national security means in order to see if it affects the validity of the security.
Your Honor, I don't think this court actually has to grapple with that. I think the question of Venezuelan law are not really before this court. I think the question before this court is whether the law that imposes a constitutional provision that imposes an express procedural requirement such as getting a legislative approval, whether that's a procedural requirement that is encompassed within the scope of validity under Section 8110.
so sorry.
Would that have been something that you discussed before you entered into the contract? I mean, doesn't our case law basically say that choice of law can override those issues? Sophisticated parties, fantastic lawyers made a choice of law decision, and now, years later, you say, no, we couldn't have done that because the National Assembly didn't approve this.
Your Honor, this court's case law in IRB and Ministers and Missioners only says that when a party selects a New York choice of law in its choice of law clause, it only selects its substantive law. It doesn't select the New York law choice of law provisions unless it expressly does so. This case is different for two reasons. One is there is a provision of the UCC Section 1301 expressly says that there are certain provisions, such as Section 8110, as to which the parties cannot contract around. They cannot select their own choice of law that will displace that provision. It's a mandatory provision. Second, in this case, the governing documents expressly stated that the parties select the choice of law rules prescribed by New York General Obligation Law 5-1401, and that section, Section 1401, says that the parties may not contract around Section UCC 1301, which makes the validity determination under Section 8110 mandatory. So this is very different. It's a mandatory provision that under New York law and under the contracted issue here, the parties could not actually have contracted around by selecting their own choice of law. And the reason is because when the legislature enacted the revised Section 8110, it actually says that it wanted to align its law with the prevailing law, that the law of the place of an entity's organization governs its power and authority to issue security. It's a predicate question to whether or not the contract, the security will be enforceable. And as to that predicate question, as to whether or not the security itself is valid, New York law says that it is the place of an entity's organization that shall govern.
And that's an issue that would be resolved theoretically in Venezuela, according to Venezuela law, perhaps along the lines of what we would refer to as a derivative action, perhaps between the only shareholder, the country of Venezuela, against the board of directors or against the officers, the board of directors versus all of that internal debate about whether or not this securities are valid would happen there among those parties. But now we have parties that are completely extraneous to the board of directors, the officers, and the shareholder that are now looking at this and say, wait a second, we're supposed to go scour every provision of every constitution and every nation in order to find out if this security is valid. What I was drilling down to, Counselor, before, and you started to address it too, is that you kept saying that it's a very narrow line of validity, definition of validity. I read your brief and I read the oral argument at the district court to say it was much larger. So now if you're going to take us down the path of narrow, how narrow is it? Are you limiting which type of constitutional provision should be reviewed? Or are you saying that any portion of a constitution must be reviewed? That's one question. Secondarily, to tie it into, I'm not sure that anyone's talked about in the briefs, but I can't figure why 8202A is not being discussed. The only other provision in that section that talks about a constitution, it says for a certificated security, which I think all of these are, you have to have a reference to the Constitution. And I've looked at all these, the notes and everything else. There's no reference to the Constitution anywhere in these certificates. So again, tell me how big a bucket validity is. Since you want to take us down a narrow path, and forgive me for going on so long, I want to focus you on my concern about this case. It seems to me like you're telling commercial people they have to really look at every item in every constitution. Is that what you're saying?
Your Honor, no. I think we would say that in determining what are the constitutional provisions affecting validity, you only have to look at which provisions impose procedural requirements as part of the issuance process, and then those are procedural requirements that govern and restrict the state-owned entities, public entities, authority and power to issue a security. And it's important to look at what happened in this case because I think it illustrates that
Would any procedural requirement satisfy your test, or does it have to be of a certain nature? So suppose the procedural requirement was 2 different forms of notice, something like that. And
No,
that's in the Constitution. Is that sufficient, or are you making a distinction between something that we might think of as less important than National Assembly approval?
Your Honor, I mean, that would be a more difficult question, but I think certainly a procedural requirement saying this has to be authorized by the legislature is a clear requirement that goes to the issuance process.
I'm trying to do the same thing that Judge Egan is trying to do, which is to see how narrow this is by parsing through what the constraints are. So I take it one constraint is it has to be in the Constitution. Yes? No?
Yes, Your Honor, it has to be.
So if it's not in the Constitution, it doesn't bite on this.
For the purpose of this case, it has to be in the Constitution. We know this from Section 822 that Your Honor referenced.
Okay, it has to be procedural.
Has to be procedural.
And procedural, at least for the purpose of this case, approval by the National Assembly is enough.
We think that you can define procedural for the purpose of this case as an approval by governmental authority, whether by the legislature or, as the treatises on opinion issuance letters indicate, an approval by the Interstate Commerce Commission, a required approval by the State Department of Public Works. These are given as examples
So
of procedural
constitutional
requirements.
for a governmental approval. We can narrow it that much?
Correct. That can be easily narrowed for this
And
case.
then it has to relate, because of the UCC, it has to relate to the issuance of securities.
It has to relate to the, even more narrow, Your Honor, to the state-owned entities' authority and power to issue a security.
Okay.
So
So
it
if it
has,
doesn't meet every one of those things, then it's not what we're talking about.
I think this court does not really need to go beyond that. And we think that that actually,
I'm not asking whether we need to go beyond it. I'm asking if that's your test. You're trying to convince us the test is narrow enough that it's not going to cause a problem, and I want to understand how narrow your test is.
Your Honor, for the purpose of resolving this case and answering the Second Circuit's question, the test can be that narrow. And we meet this test because Article 150 is exactly that type of a provision that imposes an affirmative authorization, affirmative approval requirement by the country's legislature. It is part of the issuance process. Without complying with that requirement, a state-owned entity like PDVSA cannot issue security. And that is because under Venezuelan law of public organization, PDVSA is required to comply with all conditions and restrictions imposed by law, including by the Constitution. So it is akin to a corporate law that imposes specific requirements on a private company's board of directors in terms of what approvals they need to secure and give. And to answer your Honor, question, it's important to look at what happened here, where the opinion letter that was issued as part of the issuance process expressly examined whether or not the PDVSA, the issuer, had authority under Venezuelan constitution and statutes to issue this type of security. In addition, there was a legal memorandum that expressly looked at whether or not Article 150 required a legislative approval. Now, and these opinion and the memorandum were prepared by Caracas office of a prominent international law firm. In our view, the legal memorandum which concluded that Article 150 did not actually apply to this transaction was woefully deficient. It was simply erroneous. These are issues of Venezuelan law which I'm happy to describe, but they also go beyond the certification question. But it is clear that in this particular transaction, the parties looked at the issues of Venezuela. No legal opinion here is said because the contract selects New York, in its choice of law clause, Venezuelan issues are irrelevant. That was not the position of the parties. In any kind of legal opinion issuance for a sovereign debt transaction, the legal opinion will always look at the law of issues jurisdiction and what kind of permissions and what kind of requirements are imposed there. So defining validity here as requiring compliance with constitutional procedural approvals for a state-owned entity's issuance of security is not going to create additional burden.
I'm sorry to interrupt you yet again, but I'm very concerned with how big a bucket, as I call it, is validity. And you now, to my knowledge, and maybe you'll correct me if I'm wrong, please do, but you're making this argument that it's a procedural provision of the Constitution. I never saw the word procedural in your brief or in the arguments before the district court, respectfully. So now I'm trying to figure out, okay, I thought your argument was that validity will be narrowed to a defect involving a constitutional provision. Am I correct on that? That it's got to be, invalidity has to be a defect under 8202B involving a constitutional provision. Is that how you want us to define that narrow, by tying it to the statute?
Yes, Your Honor, it can be a defect in a violation of a procedural constitutional requirement.
Why do you need the word procedural? Because
So
that's
the
the
word-
first time I've heard it. And
So actually, the word procedural is, if Your Honor looks at the article by Professor Carl Jerry, who is the editor-in-chief of the Hochland Treatise on the UCC, he expressly says that Article 150 is a type of a procedural requirement that is at the heart of the notion of validity. So, and we think that actually that makes sense, because if this court looks at Section 8202,
Well, you were limiting it further in response to my question, I think, which was that it would have to be a procedural obligation, approval requirement from a governmental entity.
yes, Your Honor.
Okay.
I think that is, and that actually that corresponds to the notion of what is required for a public entity as opposed to a purely private company to issue securities. Because if you look at the treatises by Glazer and Fitzgibbon, by John Falt, by the 1979 Association of New York Bar, that actually speaks that for a public entity, you have to look at whether the required approvals by the appropriate state authorities or governmental entities have been actually secured.
You were going to, you can finish your thought, but you mentioned you wanted to get to the common law argument. I'd want to hear about that at some point.
Yes, Your Honor, I'm happy to address it. Just to add one additional answer, because I haven't answered your Honor's question about 8202. If this court looks at 8202, it expressly references case involving Colorado constitutional provision that impose two requirements. One is a certain debt limit for municipalities before they could issue debt. And secondly, it included the provision that municipalities could issue debt that exceeded that requirement, provided that they actually put that question to the voters and obtained voter approval at the referendum. So again, these are paradigmatic examples of what constitutes validity. It is compliance with a constitutional procedural provision that imposes a certain type of approval authorization requirement.
in the Colorado case, the more recent of the two that I recall, the defense that was interjected was rejected by the intermediate court, and the Supreme Court agreed that the town, municipality could not invoke that provision. The point being is that not every constitutional provision, as I understand it, can be involved here. And also in that case, there was reference to the Constitution, as I recall, in the certificate. Because remember, that case is from the 1890s. We didn't have Article 8 until the 40s, 1940s, 50s or so. And that, the 40s to the 70s was all, if you read Hochland and you read the Uniform Laws Annotated ALI, they talk about the development of how we go from certificated securities that reference constitutions and other things to uncertificated securities that don't. So getting back to 202A, this is not an uncertificated security, but if it was, it would have to, the Constitution provision would have to be one pursuant to which the security was issued. So when it's not either mentioned in the certificate and it's not pursuant to the security is not issued pursuant to the Constitution, I'm not even sure we get to the question of invalidity here. It just doesn't apply, right?
Your Honor, I think the constitutional provisions, first of all, they don't have to specifically reference securities. For instance, the Colorado constitutional provision just imposed the debt limit or requirement of voter approval for that issuance. It didn't expressly reference security. And I think that makes sense because constitutional provisions are often written in broad terms. So again, as Professor Jerry explains, it doesn't make logical sense to require that only constitutional provisions that specifically speak about security are encompassed by the notion of validity. There is no textual basis in Section 8110 and Section 8202 for that. And Section 8202, I think, is a strong indication because it references constitutional provisions as a defect that will actually go to the issue of validity. So I think that is indication that Section 8110 and the notion of validity does encompass compliance with the constitutional provisions, particularly the procedural constitutional provisions that require governmental approval, which is easy to comply with. And that in this case was well known. It was discussed in the legal opinions. It was something that, in fact, the parties analyzed quite in detail. So there is no unfair surprise in that. Your Honor, to the choice of law provisions, we have 4 arguments, and I'm happy to elaborate on any of them. I think, firstly, there is a principle that the corporation's power and authority to enter into a contract is governed by the law of a corporation's jurisdiction. Secondly, we think the grouping of context analysis requires application of Venezuelan law because there is a question of the interest of Venezuela, which embodied in its constitutional separation of powers requirement. Third, there is a fundamental public policy exception that points to the application of Venezuelan law, and we think those, again, given the importance of the checks and balances embodied by Article 150, Venezuelan interests predominate here. And fourthly, there are choice of law.
If we agree with you on the UCC point, do we need to reach those other issues?
Your Honor, I do not believe that this court has to reach any of the choice of law issues if it agrees with us on the UCC. I mean, certainly it has discretion to do so in answer certification, but we do not believe so. And there is also the principle of contractual illegality, which I think, again, points to the application of Venezuelan law because the illegal acts occurred in Venezuela.
Thank you.
Good afternoon, Your Honors. If it please the Court, Jonathan Hurwitz for the respondents. I'd like to turn directly to the question of the uncertainty that's created by the rule that the PDVSA parties are urging, and this goes to the question that was the subject of a lot of questions from the Court
what
about
would
the scope.
your limiting principle be for validity of the security?
Sure. I think our understanding of validity, which is consistent with, we think, the legislative history, it's consistent with Hawkland, is that the focus of validity is the internal corporate governance. It's the decision-making power within a corporation when you're dealing with a corporate issuer such as Venezuela. So that it ties directly to the internal affairs doctrine that's well established in this state's laws. That, it seems to us, is the focus, and it's not just us saying that. We've cited, for example, Professor Halpern has an article that we quote and cite in our brief
So
that
if
makes
you had a
exactly that point.
constitutional provision that said, no public company, public corporation can issue a security without approval of the majority of their board and the public assembly, that would not qualify under your definition.
If it's internal to the corporation, so it requires
Just
board
part of-
approval, then that's fine. That goes to
But what if-
validity.
But you wouldn't then apply the part that required National Assembly approval?
I think the part that goes to National Assembly approval is fundamentally not about whether or not PDVSA made a decision to
What
issue
if it
these
said
securities.
no public entity can issue a valid security without the approval of the National Assembly? And it was in the Constitution.
That's clearly a closer case, and I want to explain why it's a closer case, but to answer your question directly, I would say that is still not a sort of internal decision of the corporation. It's, do they need regulatory approval or don't they need regulatory approval? And so the claim here is made that the decision by PDVSA was illegal because it didn't receive approval from the National Assembly, and that is external to the corporation.
Let me take Judge Garcia's hypothetical one more step by chopping off the end of it. What if the Constitution of Venezuela says no public entity can issue securities? That's external.
Again, it's a closer call. It's not our case. I mean, the
Yeah,
fact
I
that there
know.
may be close questions doesn't mean we don't have two distinct
What
concepts.
makes it closer in these two where you said that's closer? Is it because it's so obvious on its face that the intent is that there is no validity, they are null ab initio without the approval? Is that what makes it a
What I would
close
say-
case?
What I would say is, what the core issue here is, when you're dealing with a corporate issuer, I'm not talking about a municipality or a government agency, but with a corporate issuer, the core issue is the internal decision-making. Did the issuer actually decide to do the thing that it's doing, not is that
Yeah,
illegal
but that
or not
skips
approved?
completely whether or not they had any authority to do that issuance.
Well, I think this-
That is the point, is it not?
I don't think so, because this state has long ago said ultra vires defenses are not recognized, that you cannot, a corporation cannot go out into the world, enter into contracts, and then say, oh, we're sorry, that's not enforceable because we didn't have the authority to do that. That's
So there is no question in your mind that these securities would be valid under an application of the New York law? Is that the
Absolutely.
implication? What is the New York law that governs this validity analysis?
Well, so once you get, if I understand the question, and I'm not.
How would you
I
analyze
apologize.
this same question under New York law? I mean, whether or not the securities are valid in the first instance?
The securities here were unquestionably approved by the PDVSA board. They were approved, they were executed by people who were unquestionably authorized agents of the corporation. That renders them valid.
And that's all our law requires. New York law requires nothing more than that.
And that's what Judge Fela held, that once, if you look at New York law, there's no dispute that under New York law, these are valid and enforceable securities.
At the district court levels, I read the argument that the other side basically said the only issue is invalidity under Venezuela law, otherwise the ballgame's over.
I think that is what they said.
And this would be, just under New York law, this would be a clear question of contract law. And Mr. Counsel, what I'm getting a little worried about is, as I read some of the commentaries, these securities are akin but are not like negotiable instruments, because these types of securities carry more baggage or luggage, whatever the expression is. But it is a little like a negotiable instrument in this situation because, for example, let's assume these notes have been resold. The holder in due course concept, which is exactly addressed in 202A under Article 8.
Right.
So here, how is it that anybody's going to know what to look at in the Constitution?
I think that's
That's
exactly
what I'm
the
really
problem.
worried about, is we may create a rule, or be asked to create a rule that says invalidity is this huge bucket of everything, and you got to go fish, so to speak, in a Constitution.
I think that's exactly the problem, Your Honor. These are tradable securities. They can be traded. They do trade. There's a trading price. You can go look it up.
Would a good faith holder in the secondary market, though, be able to collect, or would they still be prohibited because of the validity of the issuer?
Well, I think our position is you only get to 8202 if the security is invalid. Once the security is determined to be invalid under 8110, then you look to 8202 and you look to questions about the good faith of the buyer. The problem there, of course, with the tradable security is which buyer do you look at, and can it really be the case that each share or each bond has a different level of enforceability depending on
Counselor, as I understand, if we accept the appellant's argument, they're void ab initio.
That is their
It's as though
argument.
they never existed.
Correct.
So nobody would be able to collect on these. And it's not so much about enforcing it, it's about being able to execute on the collateral pursuant to the guarantee. And so if you're a holder in due course, even down the road of one of these securities, you're out of luck if we sustain this argument on invalidity.
Yeah, I'm not sure that's right. I think if you sustain the argument that if you were to hold, and there's an important caveat here that I want to have a moment to get to. If the court were to determine that the securities are invalid under 8110, then you go through the analysis under 8202, which takes account of are you a good faith purchaser for value, and has there been substantial compliance, and all of the other things that 8202
If those factors are
considers.
present, they are enforceable, notwithstanding their invalidity. Isn't that
Correct.
what 8202 says?
That's exactly
Would
what
that
8202
apply
says.
to the collateral as well? So I'm a secondary holder, right? It's a constitutional provision. I'm a secondary holder. I've bought this from somebody else who had the bond. Now can I collect and enforce the
Well,
guarantee?
that's the problem with an overbroad reading of 8110 is you.
Well, I
you
want to ask you
invite all
something
these-
about the pledge agreement specifically. So the questions that were being asked by the Second Circuit ask about what law controls the governing documents. The governing documents are what's defined in the agreements as the transaction documents. Transaction documents are the indenture, and they're the notes,
And
but
the
they're
pledge
also the pledge agreement.
Correct.
The pledge agreement is between a Delaware corporation and assets held in the United States. And at least as I heard counsel's description of what he was calling a narrow rule that he wants as to validity, it wouldn't apply to the pledge agreement at all. That's still going to be governed by New York law. And if so what is and let me spin it out a little bit more. There is certainly a view of this set of agreements that says that part of the risk of Venezuela's default, we call it that, or the agreement, the notes being invalid, was addressed by the pledge agreement, choosing New York law, locating assets in the United States, as to which New York law would govern. So I'm not sure, even if it looks to me like the transaction, at least as an argument, that the transaction is structured to have accounted for this very thing.
The transaction was structured exactly to be a New York transaction, and it was structured by PDVSA. PDVSA chose to come to New York.
No, I mean something a little different than that, which is that there's an understanding that the notes might have been determined to be invalid. And I think there's even, I may have misread it, but I think there's a provision in the pledge agreement that says if PDVSA even challenges the validity of the notes, then the trustee can liquidate the collateral.
I don't recall that, but it's
Okay.
entirely possible. I mean, I don't think, look, let me address what I think is the question.
But can I just stick with that on the pledge agreement? Is the pledge agreement is signed by the holding company, the Venezuelan company, right?
Yes, it is.
Would the pledge agreement be effective without that signature? Could the Delaware company enter this agreement without the signature of the Venezuelan company?
Well, the Delaware company is a wholly owned subsidiary of PDVSA, the Venezuelan company. I'm
So
sure that
internally, right?
Right. I'm sure that the trustee and the collateral agent and the other parties would have wanted to be sure that PDVSA agrees to the terms of the pledge agreement, given its relationship to the notes. So I'm sure it was important to the counterparties that PDVSA be a signatory to that
But
document.
it could also be Delaware company's laws that say they have to get approval by the parent company to enter into this pledge agreement.
Yeah,
right?
I mean, all of these questions highlight the enormous uncertainties that are created by the claim being made here. And I do think it's important to emphasize those. I mean, the counterpart, PDVSA came to New York. This is a New York transaction, as Judge Fala found. They agreed to the application of New York law. They got unqualified opinions from a very prominent international law firm as to both New York and Venezuelan law. They got express representations in the governing documents as to
Let me ask you a different
legality.
let me ask you a different kind of question.
Sure.
So I just want to sort of circle back to some of these questions about what would be the closer question depending on the language in the Constitution. What is it? Because you're talking about the resources, the natural resources of a country, the people's resources. What would the people of Venezuela have to have done to avoid what counsel is claiming is the corrupt act? What would the theft of their resources? What could they have done?
Well, let me just start by saying, Citgo, of course, is a Delaware corporation. It does no business in Venezuela. It doesn't own any of Venezuela's natural resources. What they could have done is, number one, the government had every ability to prevent this transaction from happening. Not only the Maduro government, which was recognized by the United States at the time, the National Assembly could have said, as they did not, this is an illegal contract, this is an illegal transaction, it requires National Assembly approval, it hasn't gotten it, we will treat it as void. They said none of those things. Had they done that, there's no question that the exchange offer would have failed.
I'm sorry, post the entry of the agreement? You mean
Pre the entry
they
of
could
the
have
agreement,
disowned the agreement, is that what you're saying?
What I'm saying is,
Disavowed it, excuse me?
What I'm saying is there was in September 2016, before the agreement, before
Yeah.
the transaction closed,
I
the
see.
National Assembly issued a resolution. They criticized the government, they criticized mismanagement at PDVSA, they criticized the transaction, but as Judge Fela found, they did not say, as they could have, this transaction is illegal, it's void, it falls under Article 150 of the Constitution, it requires National Assembly approval.
And they
said
need
none
to
of those
say that
things.
because, what?
Well, they're
If it's already in the Constitution?
right. Well, there are two possibilities. One is they believed correctly, in our view, that this transaction, because it involved PDVSA, not the government, but PDVSA,
Okay.
that under a binding decision of the High Court of Venezuela, they could have concluded that they could not credibly say or accurately say that the law was that National Assembly approval was required. That was certainly the decision by Hogan Lovells, the law firm for PDVSA. The other possibility, we don't know which of these is true, but the other possibility is they chose for political reasons to try to have it both ways. They wanted to be on record criticizing the transaction, but they did not want to blow up the transaction. The reason they would not have wanted to blow up the transaction is because at the time, PDVSA was on the verge of defaulting on something like $7 billion of debt, enforceable in New York courts to largely either U.S. or international investors. Those investors, had there been a default on the existing notes, would have gone into court in New York, would have sought to attach PDVSA's assets in the United States, of which the principal one is Citgo. So Citgo was on the chopping block, not because of what was done in this transaction, it was on the chopping block because of what had been done years and years earlier, and it was already on the chopping block as of 2016, when this transaction happened.
So fundamentally, you're basically presuming the authority of the contract, right? Because, to my mind, there's no way that New York law could answer the question, is this a valid contract? Because we have no New York law that would assess Venezuelan constitutionality, right?
I guess what I say is, as a matter of New York law, New York does not recognize a claim that we, the corporation, yes, we issued shares, we signed all these papers, but we did not have authority to do that. That is an ultra vires defense that this state, both as a matter of common law and as a matter of statute, under BCL 203, has long since abandoned, as far as we know, every other state in the country.
So is this IRB Brazil?
This is IRB Brazil, this is ministers and missionaries. With those cases, and those cases are, important both for the specific holding and also for the broader principle that in the context of commercial agreements, it's incredibly important to New York that people be allowed to enter into enforceable agreements to apply New York law.
Did IRB Brazil, was that a UCC case?
IRB was not a UCC case, and I'm not suggesting, but it's a case that recognizes important New York public policies that are directly germane to how the UCC, and in particular these provisions, should be interpreted. It's a case that says that, and with both IRB and ministers say, once the parties agree on the application of New York law, there is no room for consideration of conflict of laws principles. And that goes to the common law
Unless they
issues.
specifically incorporate New York conflicts law, I think is what it says. You can do that if you want.
You can
And
do
isn't their
that.
argument that's what you did here?
Yeah, I think for purposes of the UCC, if the court were to decide, and this is the caveat that I mentioned earlier that I wanted to get to, if the court were to decide that this is a validity issue, we don't think it is, but if the court were to decide this is a validity issue, then yes, we acknowledge that that overrides the agreement because there is a carve-out, as there would have had to be in any event, to the agreement. The caveat I want to get to is that in that case, the next step is a consideration of Venezuelan law because the UCC allows you to decide on New York law as long as Venezuelan law approves it. So you would get back to the federal courts about what Venezuelan law requires.
That would not be us, though, right?
We're not, I don't think either of the parties, none of the certified
Thank you.
questions asked this court to decide on Venezuelan law. I think both of us would be happy to talk about it, probably more than you'd be willing to hear about it. I want to say, if I may, I'd like to say one other thing, and I'm happy to answer any other questions, particularly about the common law issues. In fact, let me say two things. One is a policy issue. As this court has recognized, it's foundational to, certainly consistent with this court's recognition of policies. I don't say that the court has said this, but it's foundational to the market for foreign debt in New York, that parties be allowed to enter into binding agreements to apply New York law. Investors do not want to be bound by the law of the issuer's jurisdiction, both because the law may well be uncertain, it's not as developed, there may be questions, as here, about what it means and what's required, in a way that there would likely not be under a much more, the more developed New York system, and also because investors do not want to be in a position that they are at risk of opportunistic efforts by the issuer or by the government to recharacterize their own law retroactively, which we believe is what has happened here.
Those risks can be priced or secured, right?
Well, exactly correct, which gets me to my next point, which is from the perspective of the issuer, it's a bad result if there's uncertainty, because for the issuer, that uncertainty increases the cost of debt and decreases the availability of debt. So issuers, predominantly developing countries, state-owned enterprises in developing countries, will have a harder time getting credit in New York, and will have to pay more to get credit in New York precisely because of that uncertainty. That's exactly correct. I'm happy to address the common law issues. I think we've addressed them clearly in our brief. I mean, most of the common law issues are resolved by looking at the minister's case, which tells you shouldn't be, once the parties agree on an enforceable New York choice of law provision, and by hypothesis, if we get past the UCC, that's the case here. Minister says there's no room for discussion of conflicts of laws. I'm happy to address the other common law issues if the court has questions, but otherwise we're happy to rely on what we said in our papers.
Thank you.
Thank you, Your Honors.
Counsel, I'm sure you have much you want to respond to, but could you respond to this last point about this adverse effect regarding the ability to deal with debt and credit?
Yes, Johan, I would be happy to start with that. We don't think that those concerns are well taken with respect for several reasons. First of all, in every sovereign debt transaction, there will be a legal opinion, and these legal opinions will look at whether or not the issuing entity had the power and authority to issue security under the law of that jurisdiction.
But here you say the legal opinions were wrong.
They were wrong, and this is a very peculiar case, because this is a case where an authoritarian executive, which the U.S. government later refused to recognize, derecognized, actually decided to disregard the constitutional requirements and constitutional prerogatives of democratically elected legislature of this country. Which the U.S. recognizes now as the only legitimate government entity in Venezuela. So this is a very specific case in which the executive of a foreign country actually decided to press ahead with the transaction, even though the constitutional restrictions prohibited that transaction without the legislative authorization. And in this case, also in terms of retroactivity, I don't think that's really a valid concern, because this court and the courts of the United States do not have to recognize a self-serving assurance of a foreign government that its retroactive repudiation of debt is valid. This is what the Second Circuit held in the Allied Bank case. And the Supreme Court in Animal Science said that courts of the U.S. are not bound to accept representations of foreign states on those matters. Also, I think
So again, how does validity and Article 150 come into play here?
So Article 150 is a procedural requirement that said that if a state-owned entity, and PDVSA is a state-owned entity that's part of Venezuelan public administration, if it wants to go ahead with the issuance of security in the national contract of public interest, it has to obtain the legislative authorization. It's an affirmative legislative authorization requirement.
And the internal corporate ability to act, how does that impact?
So that's why we actually think that the other side's interpretation of validity, which is limited to the internal processes and approvals that the internal company, does not work for a public entity like this. because for two reasons. One is Section 8202 expressly says constitutional provisions go to validity. And we know from the commentary that one example are constitutional provisions which limit debts. Secondly, if you look at the treatises like the Glaser and Fitzgibbon and the other treatises on the opinion letter practice, they specifically differentiate between purely private entities and public entities, public regulated entities. And they say that for regulated entities, the satisfaction of a governmental approval and obtaining of governmental permits is an issue that goes to validity. And that makes sense because a public entity cannot actually, has no power to go and issue a security without obtaining the required governmental approval. In that sense, it is functionally indistinguishable from a requirement of a board approval for a private entity.
Counselor, real quick, just don't lose your train of thought. But is it undisputed here that this is a public entity? I thought it was sort of a public entity once removed, so to speak, that it's not a public entity under Venezuela law, it's sort of once removed, as I called it. Is it undisputed it's a public entity, and that's the way?
Your Honor, I think what cannot be disputed here reasonably is that this is, PDVSA is a corporation, it's organized under Venezuelan corporate law, but it is also part of what is called in Venezuela the law of public administration. It is a decentralized public administration entity. What is not subject to dispute, it is subject both to corporate law of Venezuela and it is subject to the law of public administration of Venezuela, which requires compliance with all legal requirements, including constitutional requirements like Article 150. There is no precise analog in the United States. Amtrak maybe as a federally chartered company may be closest, but it's not exactly. It is PDVSA is a directly state-owned entity. In fact, Constitution of Venezuela mandates 100% ownership of PDVSA by Venezuelan government because of the importance of oil industry to Venezuela.
Counsel, quick turn. I'm sorry, but your light is on and everyone wants to get a question in. You started your argument at the beginning of your appearance by talking about the distinction between validity and enforceability, and that conversation popped up with your adversary. Again, do you agree with, endorse the colloquy with Justice Curran regarding the enforceability to secondary purchasers, good faith purchasers for value? Regardless of the validity, would you say that these securities would still be enforceable as to that class of purchaser?
Your Honor,
Under
the
8202?
article, the substantive defenses of Article 8202 are not implicated in, at least in the certified questions. I mean, they have not yet been briefed or discussed.
You don't want to prejudice some other argument?
I don't want to prejudice, but I think the right answer would be, if I were to guess, is that you look to the Venezuelan law to determine the validity, whether security is valid to begin with, because that's really what the...
Well, then would you agree that validity and enforceability are not co-extensive, that those are different concepts?
They're different concepts. There are two differences. You can look, once you determine whether security is valid to begin with under Article 8110, it doesn't say that the defenses, it doesn't necessarily say that defenses under Article 8202 will not apply to secondary purchasers. I mean, 8202 expressly contemplates there may be securities which are invalid because of a constitutional defect, because of noncompliance of constitutional provision, but if you meet certain requirements, bona fide purchase, lack of notice, substantial compliance, and secondary purchaser, you nevertheless may not be able, the defense of invalidity may not be a complete defense. So that's one issue. The second is, what is important is if you look at the Hochland Treatise, if you look at actually the Hochland Treatise, which now criticizes expressly the district court decision here and says district court got it wrong, and the article by Professor Jerry, who's the treatise's chief editor, they explain laws of enforceability are typically general laws. Like, for instance, a law of usury will be a law of general enforceability. No one, certainly not we, not anyone else, is intimating that to determine validity, a lawyer has to scour all constitutional legal provisions to identify those laws which may provide for a defense of enforceability. You only have to look at the narrow scope of constitutional procedural requirements in imposing affirmative approval. And that's what the district court misunderstood. It was concerned legitimately, perhaps, about not expanding validity so broadly as to swallow the entirety of corporate law, the entire notion of enforceability defenses. But as a result, it actually misinterpreted validity to the exclusion of these constitutional provisions unless they expressly address security, but that just cannot be reconciled with the examples given in the official comments of constitutional provisions that do not expressly address security, and there is no logic why only such provisions would be encompassed of validity, and there is certainly no textual support. Just a few other points too, that I think would help this court. In terms of the ultra-virus Section 203 defense, as we argued in our brief, there is a distinction because Section 203 does eliminate ultra-virus defense, but only if the initial action was otherwise lawful. So it otherwise had to be legal to begin with. Here is one example. If PDVSA entered into a hotel building contract and then tried to argue this was ultra-virus because our corporate purpose is only oil extraction, Section 203 would not recognize that defense. But here, PDVSA has express authority to issue securities. It's just that it issued securities that are invalid because it did not comply with the constitutional required procedural prerequisite. So Section 203 is really not a bar here. In terms of the summary, in terms of the National Assembly's September 2016 resolution, it is absolutely incorrect that the National Assembly kind of left anything unclear. It expressly criticized the transaction. It said it rejects the pledge of Citgo, pledge of a controlling share of Citgo. It summoned the chairman of PDVSA to explain the transaction. And what cannot be subject to dispute is it did not authorize that transaction. And the Article 150 does not say that a transaction PDVSA can issue security, but the legislature can actually reject that transaction. It requires prior approval.
I'm sorry to interrupt you, but we're going on. If we agree with you on this definition of validity of a security, hindsight, this deal would not have happened, and that just may be the way it should be. Or the interest rate would have been 50% or whatever, and you maybe had a usury defense. But so we're changing the dynamics here. This deal happened because you had this type of provision. A very good law firm didn't think this was a violation. They gave an opinion letter. Going forward, very good law firms are now going to look at the Constitution and look at broader provisions and say, hedge at least, it may or may not, this may be a national security violation, this may be whatever they have in there, resulting in either these deals don't get done or they're priced considerably more expensively in terms of an interest rate, right?
Your Honor, I think in this case, so first of all, as a factual matter, a lot of financial analysts have at the time commented that in fact this deal was legally suspect and likely invalid because National Assembly did not authorize it under Article 150. It was absolutely known. I mean, and they expressly warned that in fact this transaction is a risky transaction. Again, this is a speculation from the hindsight, but one possibility is that the risk was priced into this transaction. Under this debt swap.
What was the interest rate? I'm just curious. What was the rate, the interest rate?
So I don't remember the rate, but one number is that those bondholders that exchanged the 2017 notes for the new ones would actually obtain something analogous to like a 50% premium in terms of payments.
Increase in the principal.
Plus, it was the first time that there was a PDVSA debt offering which actually pledged controlling interest in Citgo. The 2017 notes were unsecured, so essentially they would just get back in line behind any other creditor, including currently any other credit against the Venezuelan state itself. Yeah. So the risk was known, the risk was priced into the transaction. In terms of legal opinions, if similar situation occurs and there is a legal opinion that looks at particular authorizations, again, it may conclude there is some uncertainty, but it would signal that uncertainty and that can be priced into the transaction. If there is any concern about equity in this case, there is certainly a defense of unjust enrichment which is available under both New York law and also under Venezuelan law. So it is not that even if this is the question of validity, which we think it absolutely is, and even if we prevail in the federal court under Venezuelan law, which is not a given, although we think we will, even then there is a defense of unjust enrichment that will not allow an unjust result. And in terms of policy consequences...
I'm sorry, on that point, now we're way beyond time, but the ball game is the collateral. I don't think you can get to the collateral on an unjust enrichment theory, correct?
Your Honor, you may not, but the collateral was there to make sure that you will be made whole. So in a sense, if you're actually being made whole as a result of a payment and, as a result, because you get the remedy for the unjust enrichment and you get paid, there is really, I don't think you have an equitable right to say, well, no, in fact, I want Citco because the reason I entered into this transaction and participated in that swap because I wanted to get control of Citco once you
If it's
default.
collectible,
If it is,
as
right.
an unsecured debt.
And also, I mean, and Your Honor, there is a parallel litigation involving creditors of PDVSA in Venezuela, where in fact, the federal district court in Delaware will be conducting a court-sanctioned auction of Citco and of Citco assets. So it is actually quite possible that in fact, by the time this case this case is before the federal court and federal court has to address questions of Venezuelan law, it is uncertain exactly, what would happen there. Just one last point on, consequences. If there's any systemic risk, there is actually a systemic risk that foreign sovereigns will in fact enact laws that prohibit state-owned entities from selecting New York law if they think that the choice of law clause in the contract selecting New York law will then be used to evade governmental and constitutional restrictions on those state entities' authorities. So if there is first of all, we don't think that parties to sovereign debt transactions really will shy away from selecting the law of New York, especially because New York has a sophisticated judiciary and a sophisticated commercial law. There are reasons why the parties come here. But even if there is such a risk, the risk is much greater that foreign governments will be concerned about the effects of selecting a New York choice of law and having it override constitutional restrictions on the issuing power of their governmental state-owned corporations.
Thank you.
Thank you, Your Honor.